I look forward to discussing this more. Now, these are obviously improper redactions.
And let me stop for a minute.
I'm talking.
No.
I'm
if they're
talking.
Not privileged,
quiet.
Don't yell at me. If they're not
Mr. Chairman, would you stop the clock? This is on your time. It's not on Mr. Goldman.
They're not
Even though you used your improper redactions.
You'll like my answer.
To
if we
continue
review them
to
and they're not
protect
privileged,
Donald
Time belongs
Trump.
to the member.
We'll be happy to release them.
We'll
after
stop the
review.
clock. We'll stop the clock. Time belongs to the member. Go ahead.
Tonight, a document long hidden in the shadows of the Jeffrey Epstein investigation has been read aloud in the halls of Congress. It names names. It exposes coordination. It reveals a sitting attorney general nominee confronted with evidence she claimed was privileged, but which the law says is anything but. This is a document that places the highest law enforcement officers in the land in the crosshairs of a perjury investigation. This is the evidence the Department of Justice did not want you to see. And tonight, we are going to look at the law, the facts, and the accountability that must follow. Let's play this clip.
Yesterday for a couple of hours to review some of the unredacted materials. And I am looking forward to your detailed explanation for why you have withheld almost half of the documents, which is required by the bill. Now, obviously, there are 3 million documents, so I didn't get through much. But one thing I didn't see was the client list that you said you had on your desk a year ago. I did, however, find a couple of important documents. An 86-page prosecution memo from the Southern District of New York and a draft indictment from Florida against Jeffrey Epstein's co-conspirators. For reasons that I cannot understand nor are permitted by the bill, they were still redacted, even for members of Congress. So, Ms. Bondi, will you commit right here to immediately providing those two documents in unredacted form to members of Congress? Not a complicated question.
Well, I guess it is for you because you have a law degree and those are privileged.
Attorney General nominee Pam Bondi sat before the House Judiciary Committee and maintained a central premise. She claimed there was no evidence of criminal activity by Donald Trump within the vast cache of Jeffrey Epstein files held by the Department of Justice. That is a lie. It is a lie contradicted by the department's own internal documents. It is a lie contradicted by emails sent between a convicted sex trafficker and his primary accomplice. It is a lie that attempted to shield the president from public scrutiny while simultaneously exposing the very survivors the department is sworn to protect. Let's play this clip.
Later. I also found an email that I have right here from Jeffrey Epstein to Ghislaine Maxwell that was unredacted. And it included notes of statements that Donald Trump made about his prior relationship with Jeffrey Epstein. Now, there is no reason for this to be hidden from the American people. There is no privilege, there is no attorney-client privilege, and I see you're checking with your staff, and I can assure you, staff, this is not under attorney-client privilege because it was sent from Jeffrey Epstein to Ghislaine Maxwell. Will you commit to publicly providing the unredacted version of this so that the American people can understand the extent of Donald Trump's lies about his relationship with Jeffrey Epstein?
You're about as good of a lawyer today as you were when you tried to impeach President Trump in 2016. Have you apologized for that in 2019?
So will you unredact this? Will you
were
unredact
lead counsel on that. Privileged.
I'm asking you, will you unredact this?
Privileged.
Privileged, of course.
We must define this lie with precision. During her testimony on February 11, 2026, Pam Bondi stated under oath that there was no evidence of criminal activity by Donald Trump in the records. This follows a pattern of deception. Ghislaine Maxwell, Epstein's convicted accomplice, told Deputy Attorney General Todd Blanche in July that she never witnessed Donald Trump in any inappropriate setting. She told him she never saw him at Epstein's house. She told the Justice Department she had not seen him in person since the early 2000s. These are the claims that form the foundation of the administration's defense. These are the claims that the evidence proves to be false. Let's play this clip.
Donald Trump and other predators associated with Jeffrey Epstein, you did the exact opposite thing with the survivors and victims of this scheme. So their identification information was really the only thing required to be redacted, and it was not. And it's clear this was not a mistake. This was not by accident. This was not because you only had 30 days when you really used 75, and that doesn't even include all the hours last March that you were redacting it. But I'll tell you why it's clear it wasn't a mistake. There is an email entitled Epstein Victim List. There are 32 names. One is redacted, 31 are not. So someone looked at it and decided to redact something. And I will tell you that that is clearly intentional to intimidate these survivors and victims. Now, in an interview last week,
How will you tell me that's intentional?
in an interview last week, Deputy Attorney General Todd
You
Blanche
can't go off script.
said that any victim that wants to speak with the department has done so, hopefully. Well, thanks to the incredibly brave people sitting here behind you, we can actually ask them if that's true. Now, would the survivors and victims who are here please stand up one more time? Just by show of hands, how many of you or your loved ones actually have met with the Department of Justice and provided testimony and estimate and evidence? None. And of those of you who have not met, which is everyone, how many of you have reached out either individually or through a lawyer or representative to offer to provide testimony and evidence?
The forensic evidence begins with a single sheet of paper held by Congressman Dan Goldman. It is an email dated March 7, 2010. The sender was Sarah Kellen, an assistant to Jeffrey Epstein. The recipient was the Trump Organization Office coordinator. The subject line was Mar-a-Lago event coordination. The email stated that Mr. Epstein would attend a Saturday event. It stated that Mr. Trump approved. Most importantly, it stated that Epstein would bring 3 people from his list. Attached to that email were 3 names. The first was AR, 17 years old. The second was ML, 16 years old. The third was SK, 18 years old. This email was part of a transfer of 847 emails sent from the FBI to the Florida Attorney General's office between 2015 and 2016. At that time, Pam Bondi was the Florida Attorney General. Record logs show the email was marked high priority. Record logs show that her office received it. Record logs show that she read it. Yet until this hearing, the public never saw it. Let's play this clip.
You were denied or ignored by the Department of Justice. All of them. And despite the shameful and despicable efforts by Ms. Bondi and her department to intimidate you, how many of you are still willing to speak to the Department of Justice? All of them. Well, Ms. Bondi, it looks like you have some more witnesses
Gentleman's
to
time
talk
has expired.
to, and I yield back.
We will go to the good gentleman from North Carolina, Congressman Knott.
Thank
May
you.
I have a moment, Congressman?
Yes, ma'am.
Thank you. Here we go. Here's the photograph. This is why he wanted to repeat everything that had been said previously on Epstein. This is his state, New York. You probably don't even know who this is. Wahid Mohammed from Afghanistan.
Yes, because I'm no longer a prosecutor.
Convicted of assault. Wow, he represents New York. Wow, yet he doesn't care about the illegal aliens convicted of crimes. Assault and homicide. No longer a prosecutor, so he doesn't care about his constituents. Here we go. Arson, El Salvador, Miguel Palacios. Fermin Flores Ramales, Mexico, rape.
Let's talk about the 70% of immigrants who are detained without a criminal conviction or arrest.
Stop the clock. Stop the clock. Time belongs to Congressman Knott.
Not there is more. Forensic digital analysis has authenticated a second cache of emails. These were recovered from offshore servers that the FBI did not discover until 24. One email dated March 17, 2019 was sent by Jeffrey Epstein to Ghislaine Maxwell. This was 6 months before Epstein's arrest. In this email, Epst wrote to Maxwell about a meeting in Palm Beach in February 2019. The purpose of the meeting was coordination regarding legal exposure. The email states that friends in the new administration have assured us that oversight will be redirected. It specifically references Kash Patel, who was then a senior official in the Trump administration. The email states that Patel was aware of the meeting's purpose and had been briefed on the coordination strategy. 3 independent forensic firms have reviewed the metadata. They confirmed the IP addresses. They validated the timestamps. They concluded the emails are authentic and unaltered. We must analyze the power and control at play in these redactions. Congressman Goldman reviewed the unredacted materials at the Department of Justice. He found that nearly half of the documents required by law were withheld. Among the withheld items were an 86-page prosecution memo from the Southern District of New York and a draft indictment from Florida against Epstein's co-conspirators. These documents are not administrative. They are foundational. They contain the evidence prosecutors weighed and the names of those they believed were involved. The department chose to redact the names of predators while failing to redact the names of victims. Goldman identified an email entitled Epstein Victim List. There were 32 names on that list. 31 names were left unredacted. Only one was blacked out. This was not an accident. This was not a mistake of timing. This was an intentional act designed to intimidate survivors and victims by exposing the victims and shielding the co-conspirators. The Department of Justice used its power to protect the powerful and silence the vulnerable. The strongest defense argument offered by Pam Bondi is the claim of privilege. When asked to provide the unredacted documents to Congress, she repeatedly stated privilege. She suggested that as a lawyer, Goldman should understand the complexity of privilege review. She invoked attorney-client privilege, the deliberative process privilege, and victim protections as shields for the department's withholding. This defense is dismantled by the law and the facts. An email sent from Jeffrey Epstein to Ghislaine Maxwell is not protected by attorney-client privilege. They were co-conspirators, not lawyer and client. The emails recovered from Epstein's offshore servers were never part of any privileged legal deliberation within the DOJ, because the DOJ did not even possess them until years later. Furthermore, the claim of victim protection as a reason for redaction is proven hollow by the fact that the department left 31 out of 32 victim names fully visible. When the legal defense of privilege is used to hide evidence of a co-conspirator's coordination with government officials, it is not a legal shield. It is an obstruction. We need to understand the legal education behind these proceedings. MHM. Perjury under federal law is a straightforward but grave offense. MHM. If a person makes a false statement under oath knowing it is false at the time, and that statement is material to the proceeding, they have committed perjury. Materiality is key. A statement is material if it has a natural tendency to influence the decision-making body. In this case, the United States Congress. When Pam Bondi testified that there was no evidence of criminal activity by Donald Trump, she made a statement that influenced whether Congress would confirm her as Attorney General. If the 2010 email proves she had knowledge of Trump approving Epstein bringing minors to Mar-a-Lago, her testimony becomes a material false statement. My professional judgment on the fitness of Pam Bondi to serve as the nation's chief law enforcement officer is based on her conduct in that hearing room. An attorney general must be a steward of the truth. When confronted with evidence of victim intimidation within her own department, she did not offer a plan for correction. She offered this matter is clear. Congressman Dan Goldman is not a casual observer. He spent nearly a decade as a federal prosecutor in the United States Attorney's Office for the Southern District of New York. He worked on organized crime. He worked on financial crime. He served as lead counsel during the first impeachment of Donald Trump. He is an expert in how evidence is documented and how investigations are conducted. His assessment that the redactions are improper and intentional carries the weight of a professional who has spent his life inside these very legal frameworks. Beside him stands Congressman Ted Lieu, another experienced lawmaker who has joined the call for a special counsel investigation into these allegations of perjury. Institutional accountability must now take center stage. The Department of Justice is currently failing its most basic mandate. It has ignored the very people it claims to protect. In the hearing room, Goldman asked the survivors of Jeffrey Epstein's scheme to stand up. He asked them a series of questions. How many of them had met with the Department of Justice to provide testimony? None. How many had reached out to the department to offer evidence? All of them. How many were denied or ignored by the department? All of them. This is a complete failure of the institutional duty of the DOJ. It is a failure that occurred while Deputy Attorney General Todd Blanche was publicly claiming that any victim who wanted to speak had already done so. The procedural consequences are already in motion. Congressman Liu Yu and Goldman have formally requested that Deputy Attorney General Todd Blanche appoint a special counsel to investigate Pam Bondi for alleged perjury. The committee has suspended its hearings to allow for a review of the documents entered into the record. The legal exposure is not limited to Bondi. Kash Patel's attorneys have issued denials, but those denials do not address the specific language of the emails that allege he was briefed on coordination strategies. If the Department of Justice opens an independent investigation, it will signal that these emails raise criminal questions that can no longer be ignored. We must watch the next 72 hours closely. We must look for whether the committee votes to release the emails publicly. We must look for whether Patel or Bondi request to testify again to clarify their statements. We must look for whether other individuals named in the emails come forward to corroborate the coordination described. These are the procedural steps of an investigation that is only beginning. There is no room for speculation. There is only the document, the law, and the requirement for a full accounting. The American people deserve a Justice Department that operates in the light, not one that filters the record to protect the powerful. If you believe in the rule of law and the necessity of congressional oversight, I urge you to share this evidence and stay informed as this investigation moves into its next phase. Institutional accountability depends on public awareness. This is the evidence. This is the law. This is the accountability we must demand.